We'll hear argument first this morning in Case 16-1363, Nielsen, Secretary of Homeland Security, versus Priap. Mr. Tripp.
Mr. Chief Justice, and may it please the Court, a criminal alien does not become exempt from mandatory detention by the happenstance that DHS did not arrest them immediately or promptly after they got out of jail or prison. And the best way to illustrate this point is just to look at the statutory text. And the key provision we're talking about here is 1226C2. This is the prohibition against releasing a detained criminal alien. And this is on page 4 of our merits brief. And what it says is that the Secretary may release an alien described in paragraph 1 only if it is for witness protection. And it's undisputed here that the witness protection exception does not apply and that this categorically prohibits the release on bond of anybody who is an alien described in paragraph 1. So then the question is, who are those aliens? And on paragraph 1, it's on the prior page, and it just answers that in no uncertain terms. It says, the Secretary shall take into custody, quote, any alien who is inadmissible or is deportable under these different provisions that relate to their criminal history or terrorist activities. And so an alien described in paragraph 1 is any alien who is inadmissible or is deportable under one of these provisions. In the next part of the statute —
What meaning do you give to when the alien is released? Does it command you to do anything?
Yeah, the key function of that is to tell the Secretary when to act, right? So it's aligned flush left along with the command that the Secretary shall —
So you don't see any sense of urgency in your acting? No sense of encouraging you in some way to actually do what the statute says?
We absolutely think that this conveys a sense of urgency, and I think we're in full agreement with respondents that this is directing that this is an urgent priority. It's a mandate, and it kicks in. It is triggered as soon as the alien is released. It is our key point is that the phrase "when the alien is released."
So tell me, why would you need transition rules under your reading of this statute, which there were? And the transition rules said you have 2 years, essentially, to put in place enough personnel and facilities to do what the statute requires you to do. Why did you need that 2-year period if, in your view, you have absolute discretion to pick an alien up whenever you wanted to anyway?
I think that's really not a fair characterization of our position. Our understanding is that this is a mandate. It is triggered immediately. In a very large number of cases, the arrest is going to occur immediately. This is a mandate, and this statute was going to direct that many more aliens be arrested. And so under the real concern with the transition period rules was a lack of bed space. And under both of our interpretations, this is going to drive up the number of aliens who are arrested.
But why did you need the transition rules at all? If you have discretion, as you claim to have, to decide when you're going to pick up an alien, either the day of release or, in one case before us, 11 years later, you didn't need the transition rules. You could have just done what you needed to do to create the bed space or get the personnel and start arresting people when you thought you could.
But again, I want to be clear. We don't interpret this to say that we can arrest the person whenever we want. We understand this to be a continuing, urgent obligation to arrest them right now. We need to arrest them when they get out. We need to arrest them the next day, the next month, whenever it happens. But sometimes it may not occur for years because DHS doesn't know where the person is.
Let's go to the release provision.
Right.
Paragraph 1 is an entire paragraph. It describes a type of alien and an alien who's picked up at a particular time. So if the statute intended this lack of authority to kick in if the alien only met A through D, why doesn't the statute say that?
Well, I guess
why doesn't it say paragraph 1, A through D?
A couple of responses. I think those are the only portions of the statute that actually describe the alien. The phrase "when the alien is released" doesn't describe him. It takes as a given that he's already been fully described.
It describes the type of alien we're talking about.
It
describes the person who's subject to this provision.
I don't think that's right, because it says that might be right if it said something like the Secretary shall take into custody any alien who is inadmissible and deportable, and who has not been released for more than such and such amount of time. But that's not what it says. It says when the alien is released, which I think takes as a given that he's already been fully described.